Be ready for the dictation. Start.
Leave granted. The order dated 20th August 2018 passed by the High Court of Delhi is subject matter of challenge in the present appeal. By the aforesaid order, a petition against an order passed by the Learned Trial Court on 23 January 2018 seeking permission to amend the plaint was dismissed. The appellant, as director of Siddharth Garments Pvt. Limited, filed a suit for recovery of 25 lakhs rupees along with pendant light and future interest on or about 28 May 2016. The plaintiff has claimed the said amount advanced as loan of 25 lakhs rupees remitted to the defendant through RTGS on 16 June 2013 on HDFC Bank, Delhi. It is also averred that plaintiff has given special power of attorney to Shri Navneet Gupta and that a copy of the power of attorney is enclosed. The defendant raised one of the preliminary objections in the written statement that suit has not been filed by the plaintiff and even the alleged authorized representative has not filed any document showing that he has been authorized by the above-named plaintiff. The special power of attorney is neither valid nor admissible. It was on 29 November 2016, Navneet Gupta appeared in court as power of attorney of the plaintiff to examine himself as PW1. It was at that stage, an order was passed by the Learned Trial Court to furnish address of the plaintiff and why the plaintiff should be examined through an attorney when the plaintiff is a resident of Delhi. It is thereafter, the appellant filed an application for amendment of the plaint on the ground that the counsel had inadvertently made the title of the suit wrongly as the loan was advanced through the company. Therefore, the suit was to be in the name of the company. That the present plaint is filed through the authorized representative of the plaintiff, namely Navneet Gupta, resident of 322, Kohat Enclave, Pitampura, Delhi, who has been authorized Wide Board Resolution dated 12 May 2016 to sign, verify and execute all documents, papers, complaints, applications, plaint, written statement, counterclaim, affidavits, replies, revisions, etc. and to institute, pursue and depose in all legal proceedings and court cases on behalf of Siddharth Garments Pvt. Ltd. against Mrs. Renu Chaudhary, who was given the loan of 25 lakhs rupees. The trial court declined the amendment on the ground that the application is an attempt to convert the suit filed by a private individual into a suit filed by a private limited company, which is not permissible as it completely changes the nature of the suit. It is the said order which was not interfered with by the High Court. We have heard learned counsel for the appellant, as none had appeared on behalf of the respondent. The plaint is not properly drafted inasmuch as in the memo of parties, the plaintiff is described as Varun Pava through director of Siddharth Garments Pvt. Limited, though it should have been Siddharth Garments Pvt. Limited through its director Varun Pava. Thus, it is a case of mistake of the counsel, maybe on account of lack of understanding as to how a private limited company is to sue in a suit for recovery of the amount advanced. The memo of parties is thus clearly inadvertent mistake on the part of the counsel who drafted the plaint. Such inadvertent mistake cannot be refused to be corrected when the mistake is apparent from the reading of the plaint. The rules of procedure are handmaid of justice and cannot defeat the substantive rights of the parties. It is well settled that amendment in the pleadings cannot be refused merely because of some mistake, negligence, inadvertence, or even infraction of the rules of procedure. The court always gives leave to amend the pleadings even if a party is negligent or careless, as the power to grant amendment of the pleadings is intended to serve the ends of justice and is not governed by any such narrow or technical limitations.